Hello, everyone, and welcome back to Deep Dive Daily. I am so glad you are here with us today.
Great to be here.
You know, usually when we talk about politics in a massive federal country like India, the conversation almost immediately snaps to a vertical grid. We look up and down. We think about the center versus the state, the prime minister versus the chief minister, Delhi versus, well, everywhere else.
It's the dominant narrative, right?
It absolutely is. It's the big, powerful center and the struggling states or the defiant states.
It is the natural gravity of political discourse. The power dynamic is obvious there. It's the parent-child dynamic or the boss-employee dynamic, depending on how cynical you want to be about federalism.
Right.
It grabs the headlines because it's easy to understand.
Exactly. But today, we are going to twist the lens.
Yeah.
We aren't looking up and down. We're looking side to side.
Horizontally.
We are talking about the horizontal relationship. How does Maharashtra get along with Karnataka? What happens when Odisha and Chhattisgarh both want the same water? Today, we are exploring the machinery of interstate relations.
And it is a fascinating piece of machinery because unlike the relationship between the center and a state, which has a clear hierarchy in many areas, the center holds the purse strings, the center has the residual powers.
Sure.
The relationship between two states is technically a relationship between equals. And as anyone who has ever had a neighbor knows, relationships between equals can sometimes be the most difficult to manage.
That is the perfect analogy. Neighbors fight over fences, they fight over noise, they fight over whose tree branches are hanging over whose yard.
Exactly.
In the context of India, states fight over rivers, taxes, trade barriers, and even linguistic identity.
All of the above.
So our mission today is to unpack the constitutional and legal frameworks that keep a diverse federation from literally falling apart at the seams. We are looking at a system that relies on a concept called comity.
Comity. A beautiful, slightly old-fashioned legal word. It essentially means courtesy, civility, and mutual recognition.
Okay.
It is the grease in the gears. It's the idea that even though we are separate jurisdictions, we are part of the same family, so we should treat each other's laws and decisions with respect.
But I'm guessing politeness only gets you so far.
It does. As we will see, you cannot run a country on politeness alone. You need hard laws for when things get tough.
So lay it out for us. What is the roadmap for this deep dive? What are we looking at?
Well, we have a lot of ground to cover. We are going to explore what I like to call the 4 pillars of interstate relations found directly in the Constitution, plus one major statutory addition.
4 pillars and a bonus. I like it.
First, we have the most volatile issue, water disputes, covered under Article 262. This is where things get heated.
Always.
Second, we have the diplomatic channel, interstate councils under Article 263.
Okay, so fighting and then talking.
Right. Third, the legal connective tissue. Public acts and records under Article 261. This is the paperwork that holds everything together.
The boring but essential stuff.
And fourth, the economic engine. Trade and commerce under Articles 301 to 307.
And the statutory addition. What's the 5th piece?
The zonal councils. Those were created by Parliament specifically to group states together to solve regional problems and promote what they called emotional integration.
Emotional integration. I love that. It sounds like group therapy for states.
In a way, it was meant to be.
Okay, so let's unpack this properly. And I want to start with the drama. I want to start with the water. Because nothing seems to get blood boiling quite like water flowing across a border. What happens when a river flows through 3 different states and everyone wants a piece of it?
It is the classic resource conflict, and the Constitution writers, they foresaw this. They weren't naive. They knew that rivers do not respect political boundaries.
Right, a river doesn't care where you drew a line on a map.
Exactly. A river might start in the western Ghats of Maharashtra, flow through the plateau of Karnataka, and empty into the Bay of Bengal via Andhra Pradesh. The geography of India is linked, but the political map is divided.
So who owns that water? That's the fundamental question. If it falls as rain in Maharashtra, is it Maharashtra's water? Or does the farmer at the end of the river in Andhra have a right to it?
That is the billion-dollar question. And to answer it, or at least to provide a way to answer it, we have Article 262.
Okay.
Now, this article is unique because it gives Parliament 2 very specific, very potent powers.
What's the first one?
The first is the power of adjudication. Article 262 says Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution, or control of waters of any interstate river or river valley.
Okay, so Parliament can set up a referee. That seems standard. If 2 people fight, you get a judge.
It does, but here is where it gets really interesting. The second power is an exclusion clause.
An exclusion clause.
Yes. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute.
Wait, hold on. They can lock the Supreme Court out of the room. I thought the Supreme Court was the ultimate arbiter of disputes between states.
Okay.
Article 131, right? If State A sues State B over a border fence, they go to the Supreme Court.
Precisely. Usually, if State A sues State B, they go to the Supreme Court under its original jurisdiction in Article 131. But for water, Article 262 allows Parliament to say, no, the courts stay out of this.
Why that feels counterintuitive? Why remove the highest court in the land from what is probably the most contentious issue?
Yeah.
Isn't the Supreme Court the most neutral body we have?
There is a very specific logic to it, and it goes back to the Joint Parliamentary Committee that looked at this during the framing of the legal infrastructure.
Okay.
They had a very deep debate about this. They argued that legal rights based on the analogy of private property interests in water just don't work for states.
Can you break that down? Private property interests. What does that mean in this context?
Sure. Think about how civil law works for you and me. If you and I are neighbors and I divert a stream on my land that dries up your pond, we can go to civil court.
Right.
We have property rights. The law looks at who owns the land, who has the title, and applies, rigid principles of riparian rights. The court looks at the past, who owned what, when.
Right. It's about deeds and contracts and historical precedent.
Exactly. But for a state, the interest isn't just property. It is the public interest. It is drinking water for millions, irrigation for farmers, hydroelectric power for industry, the ecology of the river basin, future planning. The committee felt that the rigid rules of law applied by a court just weren't flexible enough to handle these massive public interest issues.
So a court looks at the law as it stands.
A court looks at the law as it stands. Water disputes often require a technical solution that looks at the future. How much rain will we get? How much do we need for this new dam? What's the most equitable distribution for everyone involved? They felt they needed an extrajudicial machinery.
So they wanted a solution based on technical needs, negotiation, and equity, not just who has the better lawyer or the older deed.
Exactly. They wanted a solution that looked at the interests of the public at large, which is a much broader canvas than a typical property lawsuit. They wanted engineers and hydrologists and economists involved, not just judges interpreting statutes from the 19th century.
Okay, that makes a lot of sense. So Parliament has this power to create a special machinery. What did they do with it? Did they create this perfect system?
Well, they enacted two key laws in 1956. And the difference between them is the story of Indian federalism in a nutshell.
Two laws, both in 56.
Yes. The first was the River Boards Act of 1956.
That sounds friendly. River boards, like a homeowners association for a river.
It was meant to be. The purpose was regulation and development. The idea was that the central government could establish a board on a request of the state governments concerned. These boards would then advise the states on how to best use the river basin as a single entity.
On request. I feel like there's a catch there. A big one.
There is. The catch is that these boards were designed to be purely advisory. They were meant to help states plan together, to coordinate their efforts.
So proactive cooperation.
That was the dream. But in the rough and tumble of politics, states rarely want advice on how to share resources. They want control. They want to build their dam to win the next election, not participate in a 5-state planning exercise.
So because the initiative had to come from the states and the output was just advice, I'm guessing it didn't really take off.
It has been largely ineffective. Not a single river board has been created to date under this act.
Not one. In over 60 years.
Not one. It's the nice guy approach, and it finished last.
Sadly, yes.
Yeah.
So if the nice way didn't work, what's the hard way? I'm guessing this is where the lawyers come in.
The hard way is the second act, the Interstate Water Disputes Act of 1956.
Okay, this sounds more serious.
This is where the real action happens. This act empowers the central government to set up an ad hoc tribunal.
Ad hoc meaning temporary, created just for that specific fight.
Yes. It's not a standing court that exists forever. If 2 or more states are fighting over a river and the center decides that the dispute cannot be resolved by negotiation,
Which it often can't.
then the center sets up a tribunal specifically for that river system. And here's the kicker. The decision of that tribunal is final and binding.
And because of Article 262.
No appeal to the Supreme Court regarding the merits of the water sharing. Once the tribunal bangs the gavel, that is the law. The states have to comply.
Let's look at the data on this, because I think seeing the scale of these fights really drives the point home. You have a list here of the tribunals set up so far. It's like a timeline of Indian conflict.
Yes. Up to 2019, the center has set up 9 of these tribunals, and if you look at the dates, you can see these waves of conflict.
I'm looking at this table. 1969 was a massive year for water lawyers. It's like the Woodstock of water disputes.
It really was. In 1969, we saw 3 major tribunals established simultaneously. First, the Krishna Water Disputes Tribunal. That involved Maharashtra, Karnataka, and what was then Andhra Pradesh.
And the Krishna River is a huge lifeline for the Deccan Plateau. That's a massive area.
Absolutely. Then, in the same year, you had the Godavari Water Disputes Tribunal. That one was even more crowded. It involved Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh, and Odisha.
5 states fighting over one basin. That is immense. The logistics of that alone are staggering.
And also, in 1969, the Narmada Water Disputes Tribunal. That brought in Rajasthan and Gujarat, alongside Madhya Pradesh and Maharashtra.
So literally the entire central and southern peninsula was litigating water rights in 1969. Why that year? What was in the water, literally?
It was the era of the big dam. The Green Revolution was just starting to take hold. States realized that to develop, to feed their populations, they needed irrigation, they needed hydroelectricity.
And technology was catching up.
Exactly. The passive live and let live attitude of the past wasn't working anymore because the technology now allowed states to divert massive amounts of water for these huge projects. Everyone wanted to build their dam first.
And it didn't stop there. I see the Ravi and Bees Tribunal in 1986. That brings the conflict up north.
Yes, Punjab, Haryana, and Rajasthan. That dispute is deeply, deeply tied to the agricultural history of the Green Revolution states and, of course, the bifurcation of Punjab and Haryana in 1966. Water there is liquid gold.
And then the big one everyone knows, Kaveri.
The Kaveri Water Disputes Tribunal, set up in 1990, this is perhaps the most emotive of them all.
Involving Karnataka, Kerala, Tamil Nadu, and Puducherry.
Right. And the recurring tensions between Karnataka and Tamil Nadu over the Kaveri have led to riots, political stalemates, bans, endless negotiations. It's where the technical issue of water sharing becomes a visceral issue of regional and linguistic identity.
What stands out to me in this list, though, is that the same rivers keep coming back. I see Krishna Water Disputes Tribunal II in 2004. I thought you said the decision was final.
That is a very keen observation. It shows that these final and binding decisions often have a shelf life.
So final isn't really final.
Well, the award is final for the conditions that existed at the time. But populations grow, rainfall patterns change due to climate change, crop choices change.
Right.
In 1969, they allocated the water based on the reality of 1969. By 2004, the reality had shifted so much that Maharashtra, Karnataka, and Andhra Pradesh were back at the table for a second round.
It's like a divorce settlement that gets reopened every 30 years because the kids grew up and one person won the lottery.
That's a good way to put it. And we also see new players entering the field. Look at 2010, the Vansitara Tribunal involving Odisha and Andhra Pradesh, and the Matai Tribunal involving Goa.
Goa is interesting there. It shows that even smaller states are fiercely protective of their riparian rights. The Mahaday dispute involves Goa, Karnataka, and Maharashtra.
And the most recent one on this list is the Mahanadi Water Disputes Tribunal in 2018.
Between Odisha and Chhattisgarh.
Right. And this one highlights a really important structural issue. Remember, Chhattisgarh didn't exist in 1969.
It was carved out of Madhya Pradesh in 2000.
Exactly. When you create new states, you create new borders. Suddenly, a river that was mostly internal to Madhya Pradesh becomes an interstate river flowing into Odisha. New borders create new tribunals.
So the water machinery is essentially a series of firefighting tribunals. It's reactive. When the dam is about to burst, metaphorically or literally, we call in the judges.
Correct. But the constitution makers also wanted a place where states could talk before things got to the suing each other stage.
Right.
They wanted a forum for coordination. And that brings us to Section 2 of our deep dive, the interstate councils.
This is Article 263.
It is. Article 263 contemplates the establishment of an interstate council to effect coordination between states and also between the center and states.
The language here is interesting. It says the president can establish such a council if public interest would be served. It doesn't say he must. It's not mandatory.
That is a crucial distinction. It is an enabling provision. The president can define the nature of duties to be performed by such a council and its organization and procedure. However, the Constitution does specify 3 key duties that can be assigned to it.
Let's run through those duties. What are they?
First, inquiring into and advising upon disputes which may arise between states. Note the word advising.
Right, so unlike the water tribunal, this isn't binding. It's not a court.
Exactly. It's a space to vent, to negotiate, to find a political solution. The second duty is investigating and discussing subjects in which the states, or the center and the states, have a common interest.
That sounds like a think tank function. How do we tackle literacy? How do we manage a pandemic? What's our national policy on renewable energy?
In a way, yes. And third, making recommendations upon any such subject, and particularly for the better coordination of policy and action on it.
So if the water tribunal is the courtroom, the interstate council is the conference room.
That is a perfect way to put it. In fact, legal scholars have noted that the council's function to inquire and advise upon disputes is complementary to the Supreme Court's jurisdiction under Article 131.
How so?
The Supreme Court decides legal controversies. It decides who is right under the law. The council can deal with any controversy, legal or non-legal, political, emotional, but its role is advisory. It handles the friction that the law can't smooth over.
Now here is a surprising fact from the history books. The Constitution came into effect in 1950. But looking at your notes, a permanent interstate council wasn't actually established until 1990.
Correct.
That is a 40-year gap. Why the delay? Did they just forget about Article 263?
It is one of those mysteries of political will. For a long time, as you know, the Congress Party dominated both the center and most of the states.
The era of one-party dominance.
Right. So if the chief minister of Rajasthan had an issue with the chief minister of Punjab, they didn't really need a constitutional council. They just met at the party headquarters in Delhi or called the prime minister. Disputes were resolved within the party structure.
The informal channel was working, so they didn't need the formal one.
Exactly. But as regional parties grew and the political landscape fractured in the 1970s and 80s, the need for a formal, constitutionally backed mechanism became undeniable.
Because you couldn't just resolve things in a party meeting when the states were ruled by different, often rival parties.
Obviously.
And this is where the Sarkaria Commission comes in, right? That's a name that pops up a lot in these discussions.
Yes, the Sarkaria Commission on Center-State Relations, which worked from 1983 to 1988. They did a deep dive on this.
And what did they find?
They made a very strong case for this. They said, look, we need a permanent body under Article 263. They even recommended calling it the Intergovernmental Council to differentiate it from other bodies.
So they made the recommendation, and then action was taken.
Yes. The Janata Dal government, headed by VP Singh, finally established the Interstate Council in 1990. It was a direct response to the era of coalition politics and the recommendations of the Sarkaria Commission.
Let's talk about who is in this room. Because if you want to get anything done in India, you need the right people at the table. Who makes up the council?
It is a powerhouse composition. The chairman is the prime minister.
Okay, starting at the very top.
Then you have the chief ministers of all the states, plus the chief ministers of union territories that have legislative assemblies.
So Delhi, Puducherry, Jammu, and Kashmir now.
Correct. And for the UTs that don't have assemblies, like Ladakh or the Andaman Islands, you have their administrators. Plus, if a state is under president's rule, the governor of that state attends.
So essentially, every square inch of Indian territory is represented by its executive head. It's a meeting of all the rulers of India.
It is, but that's not all. To ensure the center's voice is balanced against this wall of chief ministers, there are 6 central cabinet ministers, including the home minister, nominated by the PM.
So it's not just the states ganging up on the center.
No, it's designed for dialogue.
Yeah.
And on top of that, 5 ministers of cabinet rank or ministers of state with independent charge are permanent invitees.
That is a huge meeting. Imagine the security detail for that room. How often do they actually meet?
The mandate is to meet at least thrice a year.
That seems optimistic. Has that happened consistently?
It is a target. The meetings have been, let's say, irregular over the years. But when they do meet, they are held in camera.
Meaning private, no press allowed inside.
Exactly. This encourages frank discussion. If the cameras were rolling, everyone would just make speeches for their voters back home. In private, they can actually negotiate. And crucially, all questions are decided by consensus.
Consensus. In a room with that many politicians from that many different parties, that sounds nearly impossible.
It is challenging, which is why, in 1996, they set up a standing committee of the council.
Ah, the classic committee to do the actual work.
It's the pre-meeting meeting. The standing committee is for continuous consultation and processing of matters. It is smaller and more nimble.
Who was on that?
It is chaired by the Union Home Minister and includes 5 Union Cabinet Ministers and 9 Chief Ministers, usually on a rotational basis. They do the heavy lifting so that when the full council meets with the PM, the agenda is prepped and the easy problems are already solved.
And they have a dedicated secretariat, too, to handle the paperwork.
Yes, the Interstate Council Secretariat, set up in 1991. Since 2011, it actually doubles as the secretariat for the zonal councils, too, which we will get to later.
Before we move on from Article 263, are there other councils under it, or is this the only one?
The president has used Article 263 to set up a few other specific, more technical bodies. For example, the Central Council of Health and Family Welfare.
Makes sense. Health is a concurrent subject.
Right. And the Central Council of Local Government, originally called the Central Council of Local Self-Government back in 1954.
And I see a reference to regional councils for sales tax.
Yes. 4 regional councils for sales tax, north, east, west, south. These were set up to coordinate tax policy before the GST era completely changed the landscape. They're largely historical now.
So Article 263 is a flexible tool. It allows the president to create a council for X whenever public interest demands coordination on a specific topic.
Precisely. It is the constitutional safety valve for cooperation.
Okay, moving on to Section 3. We have fought over water. We have sat in a conference room to discuss policy. Now let's talk about paperwork, because if I get a court order in Mumbai, does it mean anything in Kolkata?
This brings us to the full faith and credit clause in Article 261.
Sounds like a wedding vow. Full faith and credit.
It is a vow of unity for the nation's legal systems. You see, technically, the jurisdiction of each state is confined to its own territory.
Right.
The Maharashtra legislature makes laws for Maharashtra. The West Bengal courts decide cases in West Bengal. In theory, without this clause, State A could just ignore the public acts of State B.
Which would be absolute chaos. You'd cross a border and your marriage certificate or your property deed or a court judgment would suddenly be worthless paper.
Exactly. To prevent that chaos, Article 261 lays down 3 rules. First, full faith and credit is to be given throughout the territory of India to public acts, records, and judicial proceedings of the center and every state.
Can we define those terms? What counts as a public act?
It includes both legislative acts, so laws passed by the Assembly, and executive acts of government. So if the government of Tamil Nadu issues an order, the government of Kerala has to recognize that it is a valid, authentic order.
And public records.
Any official book, register, or record made by a public servant in the discharge of his official duties. So birth registers, land records, police filings, all the bureaucratic paper that makes a society function.
And judicial proceedings is self-explanatory. That applies court cases.
Yes. But, and there was always a but, the Constitution gives Parliament the power to determine the mode of proof.
The mode of proof. What does that mean?
Basically, Parliament decides how you prove a document is real. You can't just wave a piece of paper and say, this is a Kerala land deed in a Delhi court. There are rules like the Evidence Act on how that document is verified, stamped, and authenticated to prevent fraud.
Now, there is a very important distinction here regarding court judgments. You mentioned in the notes that this applies to civil courts, but not criminal ones. Can you explain that?
This is vital. Article 261 says that final judgments and orders of civil courts in any part of India are capable of execution anywhere within India.
Capable of execution, meaning if I win a lawsuit for money in Delhi against a guy who lives in Chennai,
you can take that Delhi court's judgment to a Chennai court and execute it, seize his assets, dock his wages, without having to file a fresh lawsuit.
You don't have to relitigate the whole case from scratch.
Exactly. The Chennai court recognizes the Delhi judgment as valid and helps you enforce it. It makes the entire country a single jurisdiction for civil enforcement.
That is incredibly efficient.
Right.
But this doesn't apply to criminal judgments.
No. The rule applies only to civil judgments. It does not require the courts of a state to enforce the penal laws of another state.
So if something is a crime in Bihar, like consuming alcohol, but not in Goa.
Goa is not obligated to enforce Bihar's penal laws. Criminal law is intimately tied to the specific state's police power, public order, and sovereignty. One state cannot punish someone for breaking another state's criminal code within its own borders.
That is a fascinating boundary. Civil judgments travel, criminal laws stay home.
In a manner of speaking, yes. It preserves the federal distinction in law and order while maintaining a unified civil and commercial space.
All right, let's shift gears from the courts to the economy. Section 4, we're talking about the marketplace, Articles 301 to 307.
This is Part 13th of the Constitution, and it opens with a very grand, very ambitious declaration in Article 301. Trade, commerce, and intercourse throughout the territory of India shall be free.
Throughout the territory of India. So the goal is to make the entire country one single market, from Kashmir to Kanyakumari.
Correct. The objective is to break down border barriers between states. Whether you are selling goods from Punjab to Tamil Nadu, which is interstate, or moving goods from Pune to Nagpur within Maharashtra, which is intrastate, the principle is freedom of movement.
No internal customs duties, no checkpoints that act like international borders.
That's the ideal.
But if I know anything about constitutional law, freedom is rarely absolute. There's always a yes-but clause.
Indeed, there are several. The freedom guaranteed by Article 301 is freedom from restrictions, except those provided in the very next articles, 302 to 305. It is a balancing act between the national need for free trade and the regional need for regulation.
So who can restrict this freedom?
Both Parliament and the state legislatures, but with different rules and limitations.
Okay, let's start with the big one, Parliament. How can the central government restrict trade?
Under Article 302, Parliament can impose restrictions on freedom of trade in the public interest.
Which is a very broad term.
It is. For example, regulating the movement of hazardous materials, or controlling the distribution of essential commodities like food grains during a shortage, or for national security reasons.
Does Parliament have to treat all states equally when it does this?
Generally, yes. Article 303 says Parliament cannot give preference to one state over another or discriminate between states. You can't pass a law that says industry in Gujarat gets a free pass, but industry in Bengal is restricted. That's unconstitutional.
But surely there's an exception to that. What if there's a crisis?
There is. The exception is scarcity. If there is a scarcity of goods in any part of India, say, a famine or a severe shortage of essential medicines, Parliament can make discriminatory laws to ensure that specific region gets what it needs.
That makes sense. Crisis management overrides market equality. Now, what about the state legislatures? Can they stop goods at the border?
Under Article 304, a state legislature can impose reasonable restrictions for public interest, but the bar is much, much higher. A bill for this purpose can be introduced in the legislature only with the previous sanction of the president.
So they need the center's permission just to introduce the bill, before it's even debated.
Yes. That is the check against regional protectionism. The center acts as the gatekeeper to prevent states from throwing up walls around their economies. Also, the restrictions must be reasonable and non-discriminatory.
What about taxes? I feel like states love to tax goods coming from outside to protect their local industries.
They do, but the Constitution limits this. A state can impose a tax on goods imported from other states, but only if similar goods manufactured within that state are subject to the same tax.
So no discriminatory taxes. You can't tax imported oranges at 10% and local oranges at 0%.
Exactly. If you tax the import, you must tax the local product equally. The tax has to be on the good, not on its origin. The idea is to create a level playing field.
There's one more big exception here. Nationalization, Article 305.
Yes. This is a big one. Laws providing for monopolies in favor of the center or the states are immune to the freedom of trade argument.
So if the government decides that only the state can run buses, like many state road transport corporations,
or that only the center can mine coal or run the railways,
then private players cannot sue them, saying this violates free trade under Article 301.
Correct. The state's right to create a monopoly for itself or a public corporation is protected.
Now here is a detail that really caught my eye. Article 307.
The dormant article. The ghost in the machine.
It says Parliament can appoint an appropriate authority for carrying out the purposes of these trade provisions.
Yes. It allows for the creation of an authority with powers and duties to monitor this free trade landscape. In the USA, for example, they have the Interstate Commerce Commission, which is a powerful regulator.
So do we have an Indian Interstate Commerce Commission? A trade referee?
We do not. No such authority has been appointed so far.
That is wild. The Constitution practically invites them to create a referee for the economy. And for over 70 years, Parliament's just said, no thanks, we're good.
It suggests a preference for political negotiation over independent regulation when it comes to trade disputes. The political class perhaps prefers to settle these things in the GST Council or the Interstate Council rather than handing power to an independent regulator they can't directly control.
Okay, we are heading into the final stretch. Section 5. We have covered the constitutional stuff water, councils, courts, and commerce. Now we have to talk about the zonal councils. You mentioned these are statutory, not constitutional.
Correct. They were established by an act of parliament, the States Reorganization Act of 1956.
1956 again. That year keeps coming up. It feels like the bedrock of the modern Indian state structure.
It was the pivot point of modern India. It was the year the map of India was fundamentally redrawn along linguistic lines. And because they were carving the country up into linguistic states, Maharashtra for Marathis, Andhra for Telugus, and so on, the leaders were terrified of balkanization. They feared the country would fracture into little linguistic islands that didn't talk to each other.
So the zonal councils were the glue. They were meant to counteract that fragmentation.
Exactly. The idea was to create a new layer of regional identity, to create habits of cooperation among these newly formed states. The act divided the country into 5 zones: northern, central, eastern, western, and southern.
And the logic for these zones wasn't just random, was it?
No, the act lays it out. They looked at natural divisions, river systems, means of communication, cultural affinity, and requirements of economic development and security.
Let's do a quick geography check. Where are these zones headquartered?
The Northern Zonal Council is headquartered in New Delhi. It includes states like Punjab, Haryana, Rajasthan, Himachal Pradesh, and the UTs of J&K, Ladakh, Delhi, and Chandigarh.
Okay, the central zone.
Headquartered in Allahabad, now Prayagraj. It covers the heartland: Uttar Pradesh, Uttarakhand, Chhattisgarh, and Madhya Pradesh.
Eastern zone.
Kolkata is the HQ. That's Bihar, Jharkhand, West Bengal, and Odisha.
Western zone.
Mumbai. It has Gujarat, Maharashtra, Goa, and the UTs of Dadra and Nagar Haveli and Daman and Diu.
And finally, the southern zone.
Headquartered in Chennai. That brings together Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Kerala, and the UT of Puducherry.
Who runs these things? Is it like the Interstate Council with the PM at the top?
No, the structure is slightly different, and I think deliberately so. The Union Home Minister is the common chairman for all 5 zonal councils.
The Home Minister travels a lot then.
He does. He is the link between the center and the zones. Then, the vice chairman position rotates among the chief ministers of the states in that zone. Each CM holds it for 1 year at a time.
Okay, so it's a shared leadership model at the state level.
Yeah.
And who else is in the room?
The chief minister plus 2 other ministers from each state in the zone, and the administrators of any union territories in that zone.
And I see they bring in experts, too, not politicians.
Yes, advisors. These are non-voting members, but their input is crucial. They include a person nominated by the Planning Commission, now contextually the Inti Ayog, the chief secretaries of the states, and the development commissioners.
So it's a mix of the top political leadership and the top bureaucrats.
Exactly. The goal is to move from political posturing to administrative solutions for regional problems.
What are their stated objectives? I mean, apart from just getting along.
The objectives are quite poetic, actually, for a piece of legislation. One is to achieve an emotional integration of the country.
Emotional integration.
Yeah.
That is a heavy mandate for a government body. It sounds, again, like a therapy session.
It sort of is. Another objective is to help in arresting the growth of acute state consciousness, regionalism, and particularism.
Acute state consciousness. That's a great phrase. Trying to stop people from thinking only as a Bengali or only as a Tamil, and encouraging them to think as an Indian living in a particular region with shared interests.
They also focus on removing the after effects of separation. Remember, this was 1956. Many borders were new and contested, and synchronizing economic advancement across the zone.
Now, I notice one region is conspicuously missing from those 5 zones, the Northeast.
Yes, the 7 Sisters plus Sikkim, they have their own special body, the Northeastern Council.
Was that created in 1956, too?
No, that came later. It was created by a separate act of parliament, the Northeastern Council Act of 1971.
And who is in it?
It includes Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura, and Sikkim. Sikkim was added later, in 2002.
Does it do the same thing as the other zonal councils? Is it just a 6th zone?
It has similar advisory functions, but with more teeth regarding security and development. It has to formulate a unified regional plan, which it then forwards to the center. And it has a specific mandate to review measures taken by member states for the maintenance of security and public order.
So given the history of insurgencies and the strategic importance of the border areas in the Northeast, the security component is much more prominent there.
Much more. It's a zonal council plus.
So looking back at this entire landscape, it's actually quite a complex, multi-layered web of institutions.
It is. We have the constitutional pillars. Article 262 for water-binding tribunals, because water's a matter of life and death.
Right.
Article 263 for policy advisory councils, because policy requires consensus and dialogue. Article 261 for legal recognition, so the legal system doesn't fracture at the border. And Articles 301, 307 for trade, trying to keep the market unified.
And then the statutory layer of zonal councils on top of that to handle regional integration and that emotional unity.
It is a system designed to allow distinct identities, the states, to flourish, while ensuring the machinery, the Union of India, keeps moving. It acknowledges that conflict is inevitable.
That's a key point.
It doesn't try to suppress conflict, it tries to manage it. It moves the fight from the streets to the tribunal or from the border post to the council room.
It effectively bureaucratizes conflict.
Which, in a democracy as diverse as India, is usually a much better alternative than what came before.
So what does this all mean for us today when we see these headlines?
It means that when you see headlines about a water dispute or a tax war between states, you shouldn't see it as a failure of the system. In a way, you should see it as the system struggling to work. The machinery is there. The question is always about the political will to use it effectively and in good faith.
That is a great perspective. It's not a bug, it's a feature of a diverse federation.
Exactly.
Before we sign off, is there one last thing we should chew on? A final thought for our listeners.
I want to go back to that dormant Article 307. The Constitution, the founders, they explicitly allowed for a dedicated authority to manage trade and commerce, an Indian Interstate Commerce Commission. Yet, in over 75 years, Parliament has never created it.
Why do you think that is? What does that silence tell us?
It raises a provocative question for all of us to consider. Is the political class fundamentally afraid of an independent economic regulator for interstate issues? Do they prefer the chaos or the flexibility of political negotiation over the clarity and rigidity of an independent authority? It is a silence in our constitutional history that speaks volumes about where real power lies.
That is something to think about. Why do we leave the management of the one economic unit to politicians rather than to an independent body of experts?
Indeed.
Well, on that note, we are going to wrap up this deep dive into the machinery of interstate relations. It's been a journey from river valleys to council chambers.
A pleasure as always.
Thank you so much for listening. If you enjoyed unpacking the nuts and bolts of Indian federalism with us, please like and subscribe to the channel Deep Dive Daily. It really helps us out.
And stay curious.
See you next time.